Hey everyone, welcome back to the channel. My name is Mitch Furman. I'm a criminal defense attorney here in Chicago, Illinois. Today we're going to dive into something that comes up almost in every felony case, the preliminary hearing. People often think this is the same as a trial, or that it's the day someone finds out if they're guilty or not and whether they're going to jail. That's not what it is. A preliminary hearing is a very different step in a criminal process. It can be one of the most important ones, depending on the case. So let's break it down. What is it, how it works, who is involved, and why it matters so much to anyone facing criminal charges in Illinois. A preliminary hearing in a court proceeding is where the judge decides whether the state has enough evidence for the case to move forward. The key word here is probable cause. Probable cause does not mean guilt beyond a reasonable doubt like in the trial. It just means, is there enough evidence to reasonably believe that a crime was committed and that the person being charged may have committed it? If the judge finds probable cause, the case goes up to the trial court. If the judge doesn't, then the charges can be dismissed. But wait. Just because there's no finding of probable cause and the case is dismissed does not mean it's over. Stay tuned so you can learn why the case can proceed forward even if there's no finding of probable cause. At a preliminary hearing, you will usually see, number one, the judge. The judge is the one who makes the final call about the probable cause, whether the prosecution has established one, shown one, whether one exists. The prosecutor. The prosecutor is the one that presents the evidence at the preliminary hearing. The prosecutor calls witnesses, usually police officers, who will testify as to what they discovered throughout their investigation and whether they believe that the defendant is the one that committed the crime. The defense attorney. The defense attorney will cross-examine the witnesses brought by the prosecution. They will challenge the evidence and show weaknesses in the prosecution's case. The defendant. The defendant is the person that's being accused of committing the crime. The defendant is present, but usually does not testify. The police officer will often testify about what they saw, what they learned during the investigation, and what evidence they gathered. Here's usually how it plays out. Number one, the prosecutor calls a witness, often the lead officer in the case. Number two, the witness testifies about the facts, maybe what they found at a crime scene, statements from victims or other witnesses, or physical evidence like weapons, drugs, or anything else criminal that was recovered. Number three, the defense attorney. The defense attorney does the cross-examination of the state's witnesses. The defense attorney will be asking tough questions to poke holes in the story. They will challenge the credibility of the witness and point out the weak spots in prosecution's case. 4. The judge listens to both sides and decides, is there enough probable cause for the case to move forward? It is usually quick, sometimes 15 minutes, sometimes it takes a little longer depending on this case and what kind of witnesses and how many of them are brought forward. It is nothing like a real trial you see on TV with multiple witnesses, long arguments, and a jury. What it isn't. Now let's clear up some myths. A preliminary hearing is not about finding guilt or innocence. A preliminary hearing is not the place where the jury decides somebody's fate. Stay further, and I will explain to you what happens if there is no finding of probable cause. So why does this matter so much? Well, for the prosecution, it's their chance to show the case is solid enough for the case to move forward. For the defense, it's a huge opportunity to challenge weak evidence early, expose problems in the case, and sometimes even get charges reduced or dismissed. For the defendant, it is the first real test of the case in front of a judge. What happens here can set the tone for everything that comes after. Another key benefit for the defense, discovery. We get a preview of what the state's evidence looks like at this early stage of the game. We also get to see how their witnesses might testify, what can be expected, and how to anticipate further moves. This can be incredibly valuable for building a defense strategy down the road. If the judge finds probable cause, the case gets sent to the circuit court for further proceedings. Things like arraignments, motions, plea negotiations, and eventually trial if it goes so far. If there is no finding of probable cause, the case may be dismissed. But remember, the state can sometimes recharge and refile their case if need be. So that's the breakdown of a preliminary hearing in Illinois. It's not about proving guilt or innocence. It's about making sure there's enough evidence to keep the case alive. If you found this explanation helpful, hit that like button, subscribe to the channel for more Illinois explainers, and leave your questions in the comments below. Thanks for watching, and I'll see you in the next video. What is an indictment? Indictment is another way to find probable cause. As mentioned earlier, in order for a felony case to move forward, there needs to be a finding of probable cause. There are two ways that probable cause can be found. Number one, preliminary hearing. As mentioned earlier, this is where you, your attorney, state's attorney, and the judge gather in one room where the witness is called and the testimony is given. The defense attorney gets a chance to cross-examine the witness, and the judge decides whether or not there's probable cause for the case to go forward. The other way to find probable cause is called indictment. This is where the state's attorney brings their case up to a grand jury. What is a grand jury? Grand jury is just ordinary folks that sit at a courthouse in a secluded room, and nobody but the state's attorney has access to them. These folks listen to case after case after case after case that the state's attorney bring to them for finding a probable cause. And like the judge, these common folks determine, is there probable cause? If the grand jury determines that there is probable cause, they issue what is known as a true bill of indictment, and the case proceeds further. Next step is arraignment. Thank you for watching, and stay tuned for more videos.